The legal battle between President Cyril Ramaphosa and his predecessor seems far from over. Yesterday, Ramaphosa filed his 70-page responding affidavit to former President Jacob Zuma. It will be up to a full bench now of judges to decide whether he should appear before court. Zuma is accusing Ramaphosa of being an accessory after the fact for failing to take action against arms deal prosecutor Billy Downer. The former president says Downer leaked his medical records to journalist Karyn Maughan. So we're asking the question, does Ramaphosa have any chance of legally avoiding appearing in court as Zuma hopes? Well, let's speak to a public law professor at UCT, that's Cathleen Powell, who joins us via our video link this morning. Prof, great to see you as always. Thanks very much indeed for making time. It almost feels to me that there are different facets to this particular case, but the nub of the issue, at least for tomorrow's process, to me appears to be this matter of urgency. I wonder whether you reckon the president has done well in arguing that this matter should be heard on an urgent basis.
Yes, I think he has done that part of his argument very well. For him, the urgency lies in the fact that if he doesn't get this interdict, he's going to have to appear in court on the 19th of January, which is next week, if I'm correct. So that's the urgency. And the other thing that you need for an interdict is to show that your rights will be irreparably harmed, which he has done, because his various trial rights, his right to a fair trial, right to privacy, right to dignity, right to freedom of movement are all affected. And the last thing that he needs to show is that he hasn't got any other avenue of redress, and he hasn't. So I think urgency is covered, and I think the other requirements for an interdict are also covered.
Yeah. There's a lot being said about this matter now being heard by a full bench. In fact, the Jacob Zuma Foundation itself released a statement speaking out against that. Help us, I guess, place the significance of this matter going from being heard by just one judge and now it being ventilated potentially by a full bench.
Well, it affects the chain of appeal hearings. If the matter had been referred to one judge initially, then there could have been an appeal to a full bench of the same court, the South Gauteng High Court, which would just have taken more time. Given that it's an interdict application, I don't think we need to worry about the chain of appeal that much, because it's a yes or no to take effect before the 19th of January. I think the full bench was probably chosen more because of the importance of the matter and because it's a current president trying to hold off a former president. So you wanted to start with a bench that has some weight and gravitas behind it. Sure.
If the president is granted this interdict, that doesn't mean this matter is over, does it?
No. The application for an interdict counts as Part A of the application by President Ramaphosa. Part B concerns the actual merits. So in Part A, he's saying, look, I'm telling you that this interdict, the summons and the entire legal private prosecution is invalid. And that I will argue in Part B. But while we wait to consider that matter, I want you to interdict the actual summons so that I don't have to appear in court on the 19th. So, yes, if the interdict's granted, Part B will still go ahead. It can just take a bit longer.
Sure.
It doesn't have to be all being held this week.
Right. Speaking about issues around invalidity, I mean, part of what is also being argued here is that the president is using essentially summonses that are invalid and unlawful. And that in some ways is connected to this issue around the noli prosequi certificate. Break that down for us, because the NPA in some respects has come under scrutiny for the way in which they've worded that certificate and the ways through which the former president is now using it to his advantage.
Well, the way the NPA worded it would have been in response to the request they got.
Right.
To explain whether they were prosecuting a particular matter. That's what a certificate noli prosequi is about. Remember, a private person can only take over a prosecution if the NPA said we're not doing it. So if as a private citizen you want to prosecute somebody as a criminal matter, you have to ask the NPA, look, are you guys going to do this? And the NPA will then respond with respect to that specific matter that you've raised to them. So the question to the NPA can't be, are you ever going to prosecute Cyril Ramaphosa? It will be, are you going to prosecute him with regards to this alleged offence on that date? Now, it looks like the NPA wasn't even ever asked that. The two certificates that we're talking about deal with other people, not Cyril Ramaphosa. So they deal with Billy Downer, for example. And then they deal with an offense supposedly committed on the 9th of November. Meanwhile, what Jacob Zuma is trying to prosecute President Ramaphosa for is for his actions on the 25th of November, which Jacob Zuma claims was an inadequate response to what Billy Downer did on the 9th.
Sure.
Which means that the certificate nolle prosequi has got nothing to do with Cyril Ramaphosa. And that is the main basis of Cyril Ramaphosa's plea to the court to set aside the summons. Because the actual summons is invalid, and in fact the very prosecution is invalid because it's not proceeded as is required by law, by the proper certificate nolle prosequi. And that is not the NPA's fault. The NPA issued a certificate on the basis of a query it had been asked. That certificate has now been sort of hijacked by the Jacob Zuma team, and they're trying to use it for a different prosecution on which the NPA clearly wasn't asked for its opinion.
So this argument from the Jacob Zuma Foundation that the certificate itself speaks about anybody who may have been involved in this case and by extension involves the president, as far as you're concerned, that doesn't hold water.
That's rubbish. Sorry. The certificate nolle prosequi is a technical requirement for any private person to initiate a prosecution. If that technical requirement is not taken seriously, then anybody can prosecute anybody for anything. The whole reason we have an NPA is that you have a body that are professionally equipped to check whether there's enough evidence with regard to a specific case. Now, if private prosecutors want to step in, I mean, it's a big thing they're even allowed to, but they don't have a right, a default right. That's what the NPA has. A private prosecutor has first got to show, look, the NPA is not prepared to prosecute this matter. Imagine if I were now to take the right to prosecute anybody who may even have known Billy Downer, because who knows what their connection might have been. Do you see what I mean?
Sure.
The whole point of these restrictions on private prosecutors is that it's not the same thing as a prosecution by the NPA. They can't start acquiring extra rights when the certificate refers to a specific person and a specific date.
Fascinating. We'll all see how it unfolds in court tomorrow. Always great getting your take, Professor Cathleen Powell, who is a public law professor with the University of Cape Town. Interesting times. You know, this is easily being deemed, you know, one of the most contentious legal matters, at least for 2023 so far. And once again, the former president's team and the current president's team are set to go head-to-head in the High Court sitting in Johannesburg tomorrow. Professor Cathleen Powell, once again, thanks very much indeed.